Chief Justice. Judge Cowan, you have spent the majority of your time outlining the sort of pragmatic problems of how to get things done in the Land Claims Court. And it's very admirable, your knowledge of the land ecosystem and your knowledge of the processes of the court itself. But there is another role to the position you are going to occupy, which is that of intellectual leadership. So I fear we're not giving you enough questions that are challenging you intellectually. So maybe let me fill that gap. I agree with you fully when you say the government is to blame for the problem of landlessness and land injustice. 100% they are to blame for it. They've dilly-dallied, they've adopted the wrong policies, they've defunded land, they've defunded the Land Claims Court, they've defunded the Land Claims Commission. So every charge in the charge sheet has been established. But I think that the judiciary must also take responsibility for the way in which they have handled the jurisprudence of land. Now, I want to give you 4 examples in which they have constrained the ability to reach the constitutional vision that is outlined in a very ambitious section, Section 25. Firstly, they have adopted a narrow definition of community, which has excluded numerous communities from being able to obtain land justice. And that's purely a jurisprudential thing. There's nothing in the Constitution that requires the judges, particularly of the Land Claims Court, to adopt such narrow constructs to the definition of community. Secondly, they have put restoration as an entry point to debates of feasibility, as an entry point to debates about restitution. And what that means is that you end up with an artificial argument about the feasibility of restoration, which focuses on the financial feasibility of restoration, and without asking whether or not the landowners that own Sentin live here. But you ask the same thing about communities. Are they going to live there? But the owners of Sentin are living overseas, and nobody's asking that question about them. Thirdly, they have used market value as a starting point in the assessment of compensation. Again, it was judges who decided that market value would be a starting point in the assessment. Fourthly, they have found in many cases that people that were dispossessed were in fact labor tenants, and which disables them from claiming fully fledged ownership rights because the judges have decided they were labor tenants. And then finally, they have adopted an approach to land that is sort of common law centric, right? So the debate is land property or not. Now, I've put this to you because out of the judges and the judgments I've read in the Land Claims Court, yours are the most promising, the most radical, and they show the ability to break with the straitjacket of the common law. And maybe if there is any hope, it will be in a lot of the judgments that you have written. So maybe you want to say something about the intellectual challenge of breaking with the tradition in order to give effect to the constitutional vision in Section 25.
How long do I have?
No,
I think 30 seconds.
unfortunately, he has taken all the time that is allocated to the interviewee to answer, because that was anything but one question and nothing close to short, crisp, and concise.
Judge Cohen,
Do your best.
I leave it to the Chief
Cohen.
Justice to decide what to do.
Just do your best.
Thank you, Commissioner. When I noticed in the preamble to the Land Court Act, Parliament itself speaks about the need for progressive jurisprudence, and I'm interested in that because there seems to be a recognition by Parliament itself that there's a need to shift how we're thinking about land law. And I agree with that at a high level. I think that when I look at the land space, I wonder why it's taken us so long to get to where we are. And I think we do need to shift the ground quite radically. There's so much that one can do, and we are bound by stare decisis, and stare decisis is a principle that is central to the rule of law in South Africa, which is a founding value. So as a lower court, there's so much one can do until matters ultimately get up to the Constitutional Court. So if I may use this opportunity, now that I have the audience, to suggest to the Constitutional Court that there's a critical need to have a look at some of these issues. They really do need to be scrutinized, I think, carefully. The one area where I have, I believe, managed to make some headway is in the area of cattle and grazing. And this is an issue which we canvassed at some length in the previous interview. And I know that in the case, it's the one matter where I have been overturned on appeal. And as I understand it, that case, I don't know what the status of it is, but that there are processes, those parties are seeking to go to the Constitutional Court. So it may be that there's an opportunity coming up soon, whether it's in that case, I don't know what the court will say, but whether it's in that case or in another case, we really need to rethink how we think about cattle and land. And that's precisely because of the connection between cattle dispossession and land dispossession in this country, which what we see in the court is ongoing. It's that colonial legacy of dispossession is ongoing, and that requires full frontal re-examination of the common law and how it applies in the context of land law. The issues around labour tenancy are very troubling as well, and that not only invokes concepts around community and labour tenancy, it also invokes the cutoff date. So the cutoff, everyone knows the Constitution refers to 2013, the date of the Land Act. Especially in the world of labour tenancy, many people were converted through the stroke of a pen to become labour tenants when titling happened in the late 19th century, sometimes without their knowledge. So how we think about, and that can impact in how whether one's even viewed as a community. This is a live issue before me now, so I can't go into it in much detail, but the issue of what is a community and how labour tenants are understood in that space it's a deeply troubling question that I believe needs to be looked at closely by the courts. I'm going to have an opportunity to do that now, and I've just heard argument in a matter on that. But the issues that you raise, Commissioner, are obviously they're large issues. I would love to talk about them all day. I don't think I have the space.
We don't have all day.
But yes, I agree that there's real space to shift our jurisprudence into a more progressive jurisprudence.
No, I think that